Thank you. Please take your seats. So we have here today members of the IBP and some law students and law professors, and so also members of the public and also of the media. We are also being broadcast on Facebook Live via the Facebook page of the IBP, International Law and International Affairs Committee. It's ibp.iliac. My name is Raj Palacios. I am the chairman of the IBP International Law Committee and a lecturer in international law at UP College of Law. May I now invite the National President of the Integrated Bar of the Philippines, Attorney Abjel Dan Elijah Fajardo, for his opening remarks.
Thank you, Raj. Good morning, everyone. Thank you for sparing some time, despite your busy schedules, to be with us this morning. This is a manifestation of our renewed interest in public international law, thanks to recent events, of course. Raj and I had been batchmates in the College of Law, and I had to take public international law twice because Professor Mogallona gave me a 4 in the first take. I did not take it again with him. I decided to take it again with Professor Pangalangan, who is now a judge in the ICC. So I had the benefit of education twice over on public international law. And of course, the International Law Committee is now one of the most active committees in the IBP, recently because of issues on the West Philippine Sea, the Benham Rise, and of course, very recently, the intention of the Philippines to withdraw from the ICC, the multilateral statute that led to certain, that is now witness to certain events concerning the Philippines. We are happy to have with us this morning the Agent Prosecutor for the government, the always good-looking Secretary Salvador Panelo. Sir, good morning. Later on, we will be joined by other panelists, and we wish that we can bring enlightenment not only for the audience here today, but also for the rest watching. So please enjoy. Let's have a good education this morning. Thank you.
Thank you very much, Attorney Fajardo, IBP National President. This activity is organized by the IBP together with the UP College of Law. And we also have partners. We have 5 partners. The Philippine Bar Association, a voluntary organization, the oldest in the Philippines. We also have the Lyceum of the Philippines University College of Law. We also have the University of Negros Occidental, Recoletos School of Law in Bacolod. And third, we have the University of San Agustin in Iloilo. And we also have the Center for International Law here in Manila. So this event is organized by IBP as well as the UP College of Law. And we have here this morning Professor Gigi Dizon Reyes, the College Secretary of the UP College of Law, who will give our closing remarks later. Attorney Gigi, please rise. Professor Gigi, okay. And the partners, the 5 partner institutions. The next part of the program will be the introduction of the speakers. So we have here the main speaker for the administration. He is the Chief Presidential Legal Counsel to President Rodrigo Roa Duterte. Prior to that, he had an illustrious career as a private law practitioner with expertise in constitutional, criminal, and remedial law. He was known for handling controversial and celebrated cases. He was also a professor of law at the Centro Escolar University School of Law, the University of the East College of Law, and currently at the College of Law of Pamantasan ng Lungsod ng Maynila. As Chief Presidential Legal Counsel to the President, our speaker is the primus inter pares among the President's legal advisors. As such, we assume that our speaker was instrumental in advising the President on this action that we are now discussing this morning and on preparing the statements of the Presidents on the matter. Our speaker also served as the legal advisor of the President during his 2016 presidential campaign. And we are proud to say that he was also a director of the Integrated Bar of the Philippines and a former president of the IBP Rizal chapter. Okay. He is a native of Naga, Camarines Sur, and he earned his degrees in political science, English, and law from the University of the Philippines, where he was involved in student activism during the pre-martial law period. Okay? So may I now invite on stage our distinguished speaker, the Chief Presidential Legal Counsel, Secretary Salvador Panelo.
Good morning to all of you. Thank you for that introduction. May I just make a correction? I've never been a director of the IBP. I'm just an ordinary member. I've been trying to correct that, but I don't know where they got that information. I'm not supposed to be here. You know, I just arrived from Sydney because we attended the ASEAN Australia Special Summit. But last night I received a text that I'm supposed to be here. I forgot all about it because there are so many activities that we attend to. But anyway, since the topic is on the withdrawal, let me just say that the President has decided to withdraw from the ICC simply because, one, as he said, the Rome Statute is not enforceable in this country. Why? Because it has never been published in the official gazette or in a newspaper of general circulation. And as we all know as lawyers, that is a requirement before a law can become effective. Secondly, there appears to be a concerted effort among UN officials as well as the prosecutor to discredit this president as well as his administration before the eyes of the public. He's being painted as a ruthless, heartless violator of human rights. The preliminary examination, which was announced by Special Prosecutor Bonsada, to our mind, was premature and in violation of due process as well as the presumption of innocence enunciated by the Constitution. As we all know, our Constitution gives every citizen of this country the right to be presumed innocent. And before you can deprive a person of his life, liberty, or property, due process must be accorded him. By prematurely announcing that there is a preliminary examination, the president has been pictured to be one who will be eventually charged in the ICC for crimes that fall under its jurisdiction. And as correctly pointed out by this special prosecutor, the preliminary examination is not a preliminary investigation. So why did she have to announce it? Because before ICC can take or assume jurisdiction, it has to consider first whether there is a reasonable basis to assume jurisdiction, meaning if the crimes enumerated therein would be the proper subject matter of the jurisdiction. Also, it has to consider whether or not the information received by it would pass the rules on admissibility, and whether or not investigating the respondent would be to the best interest of justice. Now, the question is, as thrown by the media, why is it that if our theory is that this Rome Statute is not enforceable in this country, why are we withdrawing? Well, the withdrawal simply is as a courtesy because we signed it. And we are telling them that we're not bound by it. Do not consider us anymore. They're saying that the withdrawal will take effect a year after we notify the Secretary General. Our theory is that we're not even bound by that. We're not bound by it simply because, as we said, there is no law to speak of. Moreover, even assuming that there is, we feel that there has been fraud and entering into that agreement, because when we entered into that agreement, we were made to believe that our Constitution would be recognized and respected, the rights of our citizens would be respected, and our laws will be recognized as well as respected. There is a law that says that before a law can become effective, it has to be published. It was never was. And so we feel that it's just right to be out of the jurisdiction of the ICC. Now they're saying that it will be against the interests of this country. But you know, let me ask you. They say that, look, the ICC was precisely drafted so that we will have a mechanism to prosecute leaders who violate human rights. And yet, did we need ICC to oust Mr. Marcos? Did we need ICC to jail Mr. Estrada? Did we need ICC to have the EDSA revolution? It's the sovereign people that will speak and protect itself. We don't need ICC. They say it will damage us. Has it damaged the United States when it withdrew from the ICC? We're the only country with Cambodia who are members in this part of the world. So I don't see anything going for us if we become member of the ICC. Having said that, I'm open for any questions coming from the audience.
Thank you very much, Secretary Panelo, for those opening statements. This activity has been couched as a legal forum, but we all know that the withdrawal of the Philippines as a party to the Rome Statute raises not only legal issues, it also raises policy issues. Okay? So the withdrawal was a legal act by the Philippine president. At the same time, it was also a national decision, one that binds the country and affects the Filipino people. So we have here in the audience and also watching on the internet not only lawyers and legal scholars, but also members of the public. So our topic will involve legal issues as well as what Secretary Panelo raised as the policy reason behind the decision to withdraw. We are open to questions from the public and from members of the audience. Please feel free to ask your questions. We have mics available and we also have pieces of paper being distributed. So does anyone have questions for Secretary Panelo? Maybe I can ask to break the ice, Mr. Secretary, if you don't mind. We understand that the primary reason, one of the main reasons for the Office of the President to say that we are not bound by the Rome Statute is that the law, the treaty, was not published in the official gazette. However, there are issues being raised with regard to the effectiveness of the Rome Statute on the Philippines under international law. We understand that the issue of publication under the official gazette is a matter that is relevant within the Philippine national legal system. But the question is whether the Philippines as a state is bound under international law to the Rome Statute, despite the absence of publication. We are looking at the Vienna Convention on the Law of Treaties, which prescribes the manner by which states express their consent to be bound to a treaty. And when they express their consent to be bound, they are presumed to be bound by the obligations that they took on under that treaty. The Vienna Convention on the Law of Treaties also says that a state may not invoke its domestic law as a ground for evading its obligations under international law. So that is the one question raised, Mr. Secretary, whether the Philippines is invoking its domestic law, the requirement for publication in the official gazette, as a way for evading its obligations under international law in violation of the Vienna Convention on the Law of Treaties.
First, what is the violation if we are not with the ICC? Second, we all know as lawyers that international law cannot prevail over municipal laws. That's the rule. In fact, there is a Supreme Court decision on that. The case of Secretary of Justice or Executive Secretary versus Lanchon, Supreme Court said that in case of any irreconcilable difference between a municipal law and international law, municipal law should prevail. This is a basic requirement. You must remember that Rome Statute is basically a penal law. And the accused, as we all know under the Constitution, must be informed of the nature of the accusation against him. That is precisely why you cannot be bound unless the accused know of what acts are deemed to be criminal before he can be subjected to jurisdiction, so that he will know how to defend himself. That is very basic. And the President feels that since there is no law to speak of, what they're doing to me now, they're dragging me into that when there is no jurisdiction to speak of because there is no law to cover the Philippines as a state. To the mind of the President, there appears to be a conspiracy among UN officials, among those who want him to be subjected to jurisdiction of the ICC and eventually convict him in violation of his rights. That is why he decided to get out of ICC. That is my response.
Thank you, Mr. Secretary. This is working.
And I'd like to respond to my question, what violation are we talking about if we are not with the ICC? Will it be in violation if we are out of jurisdiction? There are so many countries who are not even members of that. And there have been moves like one African country is already withdrawn from the jurisdiction. So is the United States of America. And it has not damaged them.
We have a question, Mr. Secretary, from Attorney M. Hill. Yes. Please introduce yourself and the organization.
Good morning, Attorney Palacios. Good morning, Attorney Palacios, and good morning, Attorney Panelo. My name is Emerlyn Hill, and I'm Senior Legal Advisor of the International Commission of Jurists. It's a global organization of judges and lawyers. Our headquarters in Geneva, and I'm based in the Asia Pacific office, which is in Bangkok. And I'm also a UP alumni, member of IBP, still paying my dues. And I closely follow what's happening in the Philippines because I cover Southeast Asia, including the Philippines. There are three things that I would like to raise, and one question, 2 points. Many of the points that you raised, Attorney Panelo, have been responded to already by the International Commission of Jurists in its letter to President Duterte, which I believe was transmitted yesterday, and copies of the letter are available outside, and some of the people in the audience, I believe, have copies of this letter. First, Attorney Palacios correctly pointed out that this is a matter of national importance, and it's the entire country that is affected by this decision. And anyone who knows me can tell you that there's nobody else in this room perhaps that wants to see this administration succeed. I would be one of those people because I want the Philippines to improve, to move on. And I want human rights, rule of law to prevail in the country. So since this is a decision that affects all of us Filipinos, has there been an extensive consultation among government agencies and even the public on this decision? That's my first decision. That's my first question. Second,
maybe we should respond immediately to that so that will not be lost. One, the president is the chief architect of foreign policy. He doesn't have to consult. He was elected to be the leader of this country. And everything that he does would be reflected, a reflection of the sentiments of the Filipino people. And to my mind, there is no need for an extensive discussion on that with respect to the other sectors of society. He has studied that. It's been there. He has been, in fact, threatening to do that, and he has finally did it.
Thank you for responding to that question, Attorney Panelo, because the way the statement was issued and even the notice and how you spoke right now, it actually seems that this is a decision that is very personal to the president and actually has an impact on the entire country. And that is really an area of concern for us because to us, it cannot be the decision of a personal, it cannot be the decision of an individual that has an impact on all.
Let me ask you, what is the effect on the withdrawal of this country from the ICC? Give me a bad effect.
Okay. One of the, well, it actually shows that the Philippines is turning its back to international rule of law. So it means that we refuse to be part of the international community. We have actually, you said that the Philippines is one of the very few countries in Asia that is a state party to the ICC. That is true. And that is actually something that we should be proud of, because we have joined this community and we are ready to combat impunity through this type of proceedings, through this court.
Are we saying now that the United States and other major countries who have withdrawn and do not want to be members are not respecting the rule of law? Precisely, it's the rule of law that the President is invoking from removing itself from the jurisdiction of the ICC.
Attorney Panelo, one thing I noticed is that we always compare ourselves to the United States. One of the things that I can say, I studied in the United States. I went to law school also in the United States. One of the things that we can say is that the United States is not the best example when it comes to international human rights law or even international law. So as a country that aims to be a responsible citizen or a responsible member of the international community, I am not sure if we should be comparing ourselves to the United States.
But even without the comparison, as I said, what effect? You said that we will come out as a violator of the rule of law, but precisely it's the President invoking the rule of law. You're violating the rule of law in this country. And our country should reign supreme over that Rome Statute, which is not enforceable in the first place. You're putting me within your jurisdiction when you cannot do that.
Well, I think you will find in our letter, number one, let me just point out that it doesn't really adequately explain the statement of the President, how the preliminary examination violates rule of law. Number two, the preliminary examination, as you clearly stated, is not an investigation, and it doesn't put the President or any other person under its jurisdiction. It's actually really the very first phase of ascertaining whether it has jurisdiction. That's why we indicated in our letter, the ICJ actually indicated in its letter, that one of the best steps that the Philippines could have taken to thwart ICC jurisdiction is to respond to the prosecutor that it is investigating all these allegations of extrajudicial killings. So instead of running away from the ICC, it should have faced it. That would have thwarted the ICC from acquiring jurisdiction.
Let me tell you something about the ICC's position. It said that the withdrawal will not affect the examination being conducted, which is again in violation of its own statute. It says that it will not be affected if the preliminary investigation or proceedings in reference to the preliminary investigation was already commenced prior to the withdrawal. But there is no preliminary investigation. It's only a preliminary examination.
Yes.
So why should they insist that they will still continue?
Well, the withdrawal only takes effect 1 year after notice to the UN Secretary General. And the acts that are complained of actually were occurred during the time that the Philippines was a state party to the ICC. Therefore, the prosecutor still can conduct a preliminary examination over these acts. That is why that's what they're saying. But it's not. It's not acquiring jurisdiction. It's examining whether there is jurisdiction over the subject matter. It's examining whether there are domestic bodies investigating and effectively prosecuting these alleged crimes.
But in its position, it has already assumed that it has jurisdiction because, according to them, it will not be affected simply because the preliminary examination has started.
The preliminary examination. Can I just
intervene.
clarify, Raj?
Sorry, just to intervene, I think we are both referring to Article 127 of the Rome Statute, and there are second paragraph has 3 parts. It talks about obligations of the state, which have vested prior to withdrawal, so these are not discharged by a withdrawing state. Second, it talks about if there is an obligation to cooperate in any pending criminal investigation or proceeding, then the obligation to cooperate will continue despite the withdrawal. The third topic on paragraph 2 is with regard to matters which are already under consideration by the International Criminal Court, and a withdrawal by the state will not prejudice the continued consideration of this pending matter. I think that's Article 127. But let me bring the discussion to the statement by the President that the withdrawal is effective immediately. So Article 127 talks about a one-year withdrawal period. In contrast, the President said withdrawal is effective immediately. And I think that the reason for the withdrawal was that the treaty itself is not binding on the ground of fraud, right? So fraud...
No, not only on the ground of fraud. It is not enforceable in this country.
Yes, yes. It's not enforceable in this country as a matter of Philippine national law, and it is not binding on the Philippines as a matter of international law on the ground of fraud. Now, fraud is a ground for withdrawing from a from a treaty under the Vienna Convention on the Law of Treaties.
Yes.
However, the language of the Vienna Convention of the Law of Treaties, to which the Philippines is a party and binding on the Philippines, talks about fraud in entering into the contract. So I would like to request Secretary Panelo and maybe to build on what Attorney M. Hill has stated on the reason for the Philippines on fraud being the ground for saying that the treaty is not binding on the Philippines. Because the Vienna Convention talks about fraud in entering into the contract. Whereas, based on the statement of the President, he's referring to fraud in the matter of implementation of the contract, where the principle of complementarity was not observed.
Yes.
So I'm just trying to get clarity from the Secretary on whether that can be a ground.
That's my second point, actually. If you may indulge me, Attorney Panelo and Attorney Palacios. My second point is in relation to fraud. If you look at the point that we made in the letter, we note that in 2017, December, the Philippine government actually made a statement at the UN General Assembly that it has reaffirmed the principles under the Rome Statute. And then the second point is that the Philippines has also actively campaigned for one of its nationals, Raul Pangalangan, to be a judge in the ICC. So if you're talking about fraud, can we not say, if we follow domestic law, can we not say that this has stopped from the Philippines from claiming fraud? Because clearly we understand what being a state party to the ICC means. That's all. Thank you.
Thank you.
You know, fraud can be discovered only after the execution of a contract. Because if you know that there is fraud, then you will never enter into this contract. As I said earlier, when we entered into that treaty, we were made to believe that our Constitution will be recognized. Our laws will be recognized. But it did not precisely. The very basic rule on publication, which makes all laws binding, was not observed. That is precisely, we're saying that we're not bound by this Rome Statute. Because it has not recognized. Even the law on complementarity, they can only assume jurisdiction if the state is unwilling or unable. But this country has shown, our state has shown that the judicial system is functioning. In fact, there was Congress investigating this extrajudicial killing, and a conclusion was made that there is no state-initiated extrajudicial killings. There are pending cases against policemen who are charged to have been abusive of their powers. So we're functioning. So even on that score, there can never be and should have not been a commencement of a preliminary examination. Because the state, our state, is precisely not only willing, but is capable of prosecuting those who are perceived to be committing most serious crimes.
Thank you very much, Secretary Panelo. Do we have other questions from the audience? Does anyone have questions? Yes?
Morning, sir. When the ICC prosecutor commenced the preliminary examination, she was careful to state that the examination was with respect to the situation in the Philippines. She did not, I think, name the president as a respondent. In fact, the statement was so general that we cannot assume that the examination was actually in response to the complaint of Attorney Sabio, who named the specific respondents. Is there any indication in your office that the president is actually being investigated by the ICC prosecutor?
Whether there's any indication
There's
in the Office of the President
if
that...
there is communication from the ICC prosecutor that would indicate that it is the president and the other respondents named in the complaint of Attorney Sabio who are the subject of the examination.
Yeah, as far as I know, there is communication. And you must remember that in the statement of that special prosecutor, it says that they will come in only if the state is unwilling or unable. And she said also that the reason for that is because municipal laws prevail over international laws. She said that in the statement. And then she proceeded with a preliminary examination. What's the purpose of announcing? They could have done that silently. What's the reason for the public disclosure of a preliminary examination? And then at the same time saying that, you know, there are violations in the Philippines, we're concerned about that, and so we're doing this.
Thank you, Secretary Panelo. I'd like to raise the matter of the immediate effectivity of the withdrawal and the ground for the withdrawal. We understand that the statement of the President was issued last Wednesday with regard to the immediate withdrawal of the Philippines as party to the Rome Statute. And by Friday, Manila time, meaning Thursday in New York, the Philippine representative to the UN delivered to the representative of the UN Secretary General a letter notifying the UN Secretary General of the decision of the Philippines to withdraw as a party to the Rome Statute. And I think the phrase used there was withdraw in accordance with the relevant provisions of the Rome Statute. So, which raises the question of whether we are still insisting on the immediate effectivity of the withdrawal, or we are abiding by the relevant provisions of the Rome Statute, which provides for a one-year withdrawal period.
Well, to my mind, the note verbale was more of a courtesy to the ICC, because precisely the theory is there's no law to speak of, but you have already acquired jurisdiction over my person. So I'm telling you that we're not bound by that.
Okay. So Secretary Panelo has another appointment, and we'd like to invite him to deliver his closing remarks, and then we'll move on to our next speaker, if available.
Well, I think I have already said my piece, so let's give the chance to Commissioner Cadiz to give his position paper.
Okay, thank you very much, Secretary Panelo.
Thank you.
Our next speaker is with us this morning, and he is the officer in charge of the Commission on Human Rights. The Commission on Human Rights is a body created by the 1987 Philippine Constitution and described as an independent office. And the Commission has a mandate under the Philippine Constitution, which includes the monitoring of the obligations of the Philippines under international law human rights treaties. Okay? So our next speaker is the focal commissioner of the Commission on Human Rights for Business and Human Rights, Environment, International Humanitarian Law, Peace, and Sustainable Development Goals. Prior to his appointment, he was a private law practitioner specializing in litigation while being the executive director of Libertas, a non-governmental organization which envisions an informed and empowered citizenry adhering to the rule of law and working within the framework of a functional democracy. Currently, our next speaker oversees the CHR's Center for Crisis, Conflict, and Humanitarian Rights, its Human Rights Education and Promotion Program, and the pending case with regard to climate change, which has been filed before the CHR. Our speaker is also a graduate of the University of the Philippines with degrees in philosophy and law. May I now invite to the stage Commissioner Roberto Eugenio Cadiz.
Sorry, I have to apologize. I think we were 2 hours in traffic. I live in Quezon City and I don't normally anymore go to Makati or even Ortigas unless there are occasions like this. And I didn't realize it at this hour because my office is in CHR is in UP Diliman and I live in Loyola Heights. So pabaliktad yung direction ko, 15 minutes. I didn't realize that now it takes more than an hour, almost two, from Katipunan to this beautiful campus. Anyway, thank you very much for inviting me. Thank you, President Fajardo, Professor Reyes. Is she here? There. Okay. Professor Pala. Thank you. Anyway, position of the parties on the issue have since last week have been clarified very well already. All over print, broadcast, and social media, and I was telling one of my staffers on the way here that the position of the parties have been beaten to death. I'm sure all of us lawyers and law students are very familiar with all this. So I will not waste much of your time. I also imagine that later on si Tony Viña will be, I've been reading his articles on this. So just let me quickly essay the position of the CHR this issue, then let me proceed to other matters which I think more important than the legal activities. The issues propounded to us was number one, whether withdrawal will take effect immediately. We've issued statements regarding this matter. Our position is that based on Article 127 of the Rome Statute, the withdrawal is not effective immediately. The withdrawal takes effect 1 year upon the formal transmission of the letter of withdrawal, the note verbale, to the Secretary General of the United Nations. So I believe that it was transmitted last Friday, Manila time, and so a year from now, Manila time, the withdrawal takes effect. But we also take the position that the withdrawal cannot just be done by the office of the president, by the president. In the same manner that the treaty cannot be entered just by the president, it has to be ratified by 2/3 of all the members of the Senate. In short, the wisdom of the Senate plays a role into the entry in the entry into the treaty. So must also the Senate be consulted. So must also the Senate ratify the withdrawal or the exit from the treaty. And we also want to take note of the fact that in a resolution signed by, I believe, 14 members, no? In 2017, expressing the sense of the Senate, 14 senators during the presidency of Senator Drilon expressed the position, took that position that the Senate must be consulted in the withdrawal. So that's the position of the CHR now. Can the withdrawal be made on the ground of fraud? I think that was the other question propounded. Actually, if you look at the Rome Statute, I don't know what Attorney Panelo mentioned while I was not here, but there's no requirement of any ground that must be invoked for the withdrawal. Am I correct, Attorney Abdiel? Wala. You don't even have to raise the issue of fraud. You can just withdraw and wait 1 year. And assuming that if the Senate needs to be consulted, and the Senate does give its consent, you don't even need to invoke fraud. So I don't really know why the President in his letter was raising the issue of fraud. This is the kind of exit where you do not need to justify why you are taking that position. But speaking of fraud, I just wanted to comment. We were discussing it within the commission last week. Who committed the fraud against the Philippine state? This is not an ordinary contract between two parties, a civil contract. No? This is a treaty involving more than 123 state parties. The 123 or 22 or so other state parties committed the fraud against the Philippines as a state party. Besides, I think it's been pointed out several times already that this is not a case, in this particular case, this is not a case where the Philippines was just invited to join the treaty after it was drafted. We were actually an active part in the drafting of the treaty. So on two levels, no? Number one, how can, more than 100 state parties engage in fraud or mislead the Philippines into entering into a treaty that is that it does not understand, or that there was concealment of some sort. But more than that, we were actually part of the drafting of the treaty. Kung may fraud nga, baka tayo pa kasi we belong to the core of the parties who drafted the treaty. And we were very proud of that, actually. In fact, si spokesperson Harry Roque was gloating at the time, and very, he was issuing so many public statements, boasting of the fact that the Philippines played a major role in the crafting of this statute. Will the withdrawal affect the preliminary examination? No, because according to, again, Article 127, since the withdrawal takes effect 1 year hence, and since the court has already started its process, preliminary examination, it's too late in the day to invoke lack of jurisdiction of the ICC over the so-called extrajudicial killings in this so-called war against drugs. Yeah, I prematurely answered the other question. The Senate concurrence is required. It is we have taken the position, we have issued a position paper actually, that the Senate concurrence must be secured, 2/3 of all the members of the Senate. And then we were also reviewing the statement, at least the summary released by Presidential Counsel Sal Panelo, and many arguments were raised therein, and I take note of at least 4 important arguments which I think they were trying to really emphasize. Number 1 is the non-compliance with the provisions of the Civil Code, Article 2, that it was not published in the official gazette or in a newspaper of general circulation, and because this is a requirement for the effectivity of domestic laws, and since this treaty was not published therein, therefore it is an invalid treaty, as if the treaty is an ordinary domestic law. We take the position that the requirement of such a publication in the official gazette does not apply to this case. Nonetheless, we also take note of the fact that actually notice was published within the official gazette. I stand to be corrected, no? If as I said, hindi ko narinig masyado kasi sinabi ni Secretary Panelo, but I believe that notice was published within the official gazette of the fact that we entered into this treaty and that it was ratified by the Senate. What they are saying perhaps is that the statute itself was not published. But if you're talking of publication, there was substantial compliance in terms of notifying the world that the Rome Statute, that we have entered into the Rome Statute as a state party, and that the entrance was with the concurrence of 2/3 of all the members of the Senate. It was also stated therein in the position paper, in the letter of the President, that the fact of preliminary examination violated his due process rights, and the presumption of innocence in his favor. I think it's the other way around. The fact that it's being announced, well, for example, but definitely mere announcement of that you are being examined, how can that be a violation of your due process right? Your due process rights will be violated if, after being informed, you are not given the opportunity to respond. Besides, this is not yet an investigation. No? We're not yet into actual investigation, as all of us know. We are just, the ICC is just in that preliminary stage of determining whether the allegations in the communication sent by the three parties, Attorney Sabio, Representative Gary Alejano, and Senator Trillanes, whether the allegations contained in their communication to the ICC actually constitute crimes against humanity. Because in the stage of preliminary examination, two determinations have to be made by the prosecutor. First, it's a paper determination. No? Looking at the allegations, pasok ba to sa crime against humanity? Kasi kung hindi pasok doon sa apat na crimes mentioned in the Rome Statute, then even if those crimes have been committed, since they are not within the purview of the Rome Statute, then the criminal court will not take cognizance of the case. So that's the first determination being made by the prosecutor. The second determination is that, okay, assuming that these acts do constitute crimes against humanity, are they being properly addressed within the judicial system or within the domestic laws of that country? Is there proper remedy? Is there serious prosecution or investigation happening? Is there any real possibility of justice being obtained by the victims in this case? Because if the judicial system within the municipal law or municipal courts of that country, in this case the Philippines, are working, even if they're crimes against humanity, under the principle of complementarity, the International Criminal Court will not take jurisdiction over the case. So that's what's happening now within that stage of preliminary examination. Are the acts constitutive of the acts mentioned under the Rome Statute? And are these acts being genuinely investigated? If they are being genuinely investigated, then the International Criminal Court will just be too happy looking for other cases around the globe to investigate. Reference in the statement of the President was also made in regard to certain statements made by the Office of the High Commissioner on Human Rights and even, some other UN personalities. Which he felt were personal attacks against him. And citing these statements, he now says that his due process rights and presumption of innocence have been violated. I cannot imagine how. In the first place, the persons who issued those statements are outside of the International Criminal Court. The International Criminal Court, by the way, is an independent body. It's independent of the UN. So, even assuming that derogatory remarks have been made by certain officers in the UN but outside of the ICC, these statements cannot be invoked by the President as violating his due process rights. It's just like, if in a domestic case, you have a case before a judge and somebody outside of the court, probably a friend of the judge, we don't know, says something, equivalent to a prejudgment of the case. But he's not part of the court. How can you invoke the statement of these persons to challenge the jurisdiction of the court? They're outside the process of the ICC. But there seems to be a conflation of issues. Parang ang nangyari dito, pinagsama-sama niya lahat, yung EU, yung UN, yung criminal court, lahat kayo galit sa akin. There has to be some nuancing on the part of the president. He cannot just be blindly lashing at the international community and lumping them together as enemies, and therefore I have to withdraw from the International Criminal Court because of this. Parang the sense that we get is that he has a feeling that the international community as a universe is against him and out to get him. So perceived personal attacks is not ground for withdrawal of our state from the ICC. So I address this to the students. We have to look at the purpose of behind the creation of the International Criminal Court and the principles governing that body. The framing of the International Criminal Court is that we are one people. We are not Filipinos. We are not, South Africans. We are not we are one humanity. That is the framing. It's not, bakit kami pinag-iinitan ng criminal court, International Criminal Court? Bakit hindi nyo habulan si ganito at si ganyan? Because under the frame of the International Court, it's not the race, it's not the people, it's the commission of the crime. No, it's one analogy was made. Although we do recognize, given the political realities of, that there might be biases, but it's really not so much of. It's like when you're a fisherman, you go out to the sea, you catch a tuna, and then the tuna complains, why don't you catch all the fish in the sea? It's something like that, no? We do recognize that there are politics, certain personalities are harder to subject to the process of the International Criminal Court. But as a general rule, we believe that at least the prosecutor in this case is not motivated by politics or personal vengeance or vendetta. In fact, many warnings have been made to our president by the International Criminal Court from the very beginning to please stop the extrajudicial killings, and those that already have been committed, please investigate them seriously, or we might take due cognizance of these cases. But apparently the president he has his own reasons, refused to take heed, and now the International Court has started its process. Honestly, objectively, we don't see any reason why the International Criminal Court or the prosecutor in this case. We don't see any motive that would support the notion being propounded by the President that is being singled out. The other important framework governing the creation of the International Criminal Court is that grave crimes are a threat to peace, world peace, to the well-being and security of the world. It is, in this day and age, there are no more domestic issues. All domestic human rights issues are international human rights issues. And all international human rights issues are domestic issues, in a sense. And that's why when things are happening to the Rohingya people, the world speaks out. Because we are one humanity. This is one reality that a new consciousness, actually it's no longer new, no? But we are one world. No? When a Filipino is killed, people from other parts of the world, especially if the killing is heinous, non-Filipinos will feel it, and they will, as a human being, they will empathize with that person, and they will say it is wrong, and that it should be corrected, and the perpetrator should be punished. And these egregious crimes are, again, crimes against humanity. Hindi na yung wala kaming pakaalam, bayaan mo silang mga Pilipino magkadamatay dyan. O bayaan mo yung mga Afrikano, yung mga Rohingyans na sunugin yung mga communities sila doon sa Burma, or pabayaan mo kahit na tinotorture sila kung saan-saan. So that's really, for the students, that's really the framing of the International Criminal Court. We are now one world. And if people from other parts of the world are seeing that grave injustices are committed in the other side of the world, and that side of the world is not addressing it, then we will do something about that. So, we at the CHR, we do not see the ICC as a mechanism that encroaches upon the sovereignty of the state parties, but we see it as a mechanism that complements the mechanisms within that sovereign state. We see it, I think I mentioned this earlier, as an accountability mechanism for individuals committing crimes within their territories, or even against the people or people in other territories. We do not see it as a court that is to be feared by innocent people, but is to be welcomed by those being oppressed by other people, and who cannot find justice within their territories. Finally, we'd like to focus on, rather than discuss the legal niceties or the legal nuances surrounding the withdrawal. Our message really sa CHR is for the Duterte administration to squarely face the processes that has now been triggered by the ICC. Primarily, this administration should now see this as a signal to it to start reining in on extrajudicial killings. Let's not beat around the bush. We all know that extrajudicial killings are happening here every day. Some people, maybe they don't talk about it. Even those who say that it's not happening, they know in there. We're not a stupid people. Maybe if 10, 20, 30, 100, 200. But if thousands are already being killed, and you know that nobody is being brought, no cases, serious cases are being filed, and you see the pattern, it's very clear that extrajudicial killings are going on. From the very beginning, even when he was just campaigning for presidency, the signal was already clear that he was going to do what he's doing now. And we all know that he was doing it in Davao when he was mayor. And now there's a threat that he will be finally brought to justice. So we all know that maybe the message being sent now to the administration is for it's about time to stop extrajudicial killings. There's a real threat now, if not domestically, internationally. He can be brought before the bar of justice. We cannot bring back to life all those that have already been killed, especially innocent children. We all know who these people are. But maybe it's about time to stop adding to these, victims. So the message really is, before to the present administration, is to stop the killings. And maybe there's still, hope for these people if they can show that despite what happened, we are now willing to mend our ways. Who knows? Maybe the International Criminal Court will now look the other way and say, I'm not saying that that's what they're going to do. But if there is a mending of ways, maybe, who knows? Maybe he will outlive. No. Maybe he will, these are all maybes. I just want to, send that message that, stop the killings. Baka makalusot ka pa. Because if after all this, you persist in doing what you're doing, and then there's already that warning, and you're even mocking the international community. Remember, for the students, the International Criminal Court is not a court to 20 or so judges and prosecutors. This is a court of more than 100 countries. This is a treaty. This is the world community hounding you. Looking at you. It's not Bansuda just looking at you. When you mock Bansuda, you're not mocking one person. You're mocking all the state parties that have decided to come together to set up the system, to address impunity, and to, put a stop to all these terrible, egregious crimes. So, our message from the CHR is, instead of playing legal gobbledygook with the international community, which is guaranteed not to work, but only exacerbate the legal problems of the administration, stop the extrajudicial killings, cooperate with the process, and don't politicize and propagandize. Maybe you can convince our people here with your propaganda. But the ball is no longer just within your court. Will those people believe your propaganda outside? Dumating na ba siya? No? So anyway, I'll stop there. Might be rambling already. Okay, but thank you very much for listening to our little rumbles.
Thank you very much, Commissioner Cadiz. Thank you for sharing the clear message of CHR on this issue, on the issue of extrajudicial killings and impunity. Thank you also for expressing the position of CHR on the legal issues that we shared with you in preparation for this forum. And second, thank you also for expressing the views of CHR on the legal arguments being used by the administration to justify its position to withdraw the Philippines from the Rome Statute, particularly the ineffectiveness of the Rome Statute for lack of publication and the lack of the argument that there is lack of due process on the ground of bias. As we said, the withdrawal from the Rome Statute is not only a legal action by the Philippine state, which needs to be done in accordance with rules. It is also an act of the Philippine Republic. It is a national decision which affects the country and impacts the Filipino people. Even though it's an action by the executive, it binds the entire country and impacts the entire population. We have invited Professor Viña, but he is tied up, I think, in traffic. So we will proceed with entertaining questions from the audience addressed to Commissioner Cadiz. We have questions. Yes, please, sir. Please stand and let us know your name, please.
Yeah, I am Virgilio Reyes, former ambassador to Italy and to South Africa. Virgilio Reyes, former ambassador to South Africa and to Italy.
South Africa.
Yes, would you kindly comment on the statement by Mr. Panelo that the President is the chief architect of foreign policy and that therefore the Senate and the Filipino people should automatically go with any statement or decision that he makes in this regard?
Should automatically
go with the decision or statement that he makes.
That's so obviously wrong. Any law student would know that just by reading the Constitution. The President cannot automatically bind us in certain foreign agreements or treaties, by the mere fact that the Constitution requires ratification of all treaties entered into by the President by a vote of 2/3 of all the members of the Senate, by all 2/3 of all its members, would already show that the wisdom that the people have requires that the wisdom of the Senate be involved in this process. There are obviously certain acts that the President, declaring war, entering into treaties, and even withdrawal from treaties. These all need to be consented to by the Senate. I'm sure, Ambassador, you will have more examples in your mind where certain branches of government, especially the legislative branch, will have to be. There's Professor Tony Laviña, I believe. I'm happy that you're here because I'm having a hard time answering some of the questions here. Anyway, so that's obviously a mistake. I mean, everybody knows, even Sal Panelo knows that. Come on, let's not. But unless he's saying that he's ignorant, But we realize the political dynamics going on here. Harry Roque is a perfect example. He just said, when I accepted the position of spokesperson, essentially my mind shut. And I assume now the mind of the President. Parang naging alter ego na siya 100%. And even in this dynamic, if you notice yung withdrawal sa ICC, napansin niyo ba yung dalawang posisyon magkaibang posisyon ni Harry Roque at ni Panelo? In the beginning, the President was issuing conflicting statements. He was saying, I'm not afraid of the ICC. I will go there and defend myself. He was essentially recognizing the jurisdiction of the ICC. But at the same time, he was saying also certain things that would detract from accepting jurisdiction. And that's the side of the camp of Sal Panelo. But now, finally, he has taken the position, mukhang ang nagwagi is the camp of Sal Panelo. That's why he was the one who was, dala-dala niya yung statement. Siya yung nag-press con, siya na yung gano. And that's why Harry Roque is not here. Because if Harry Roque were here and Sal Panelo were here, mag-aaway silang dalawa. Nakakahiya sa media. People know, but the political dynamic is when you do accept this job, when you join the president, the official family, then you have to suspend you have to subsume your beliefs, your positions to that of the presidents. Otherwise, get out of the kitchen. Sorry, nag-rumble na. I hope, Ambassador, may nasagot akong konti. Yeah, I think that's better. Tony, go na.
We have Professor Laviña here. Sorry, we'll have Professor Laviña deliver his opening statement for a few minutes, maybe, maximum of 10. And then we'll request Professor Laviña to join us here to field questions from the audience because there are many more questions. Yes, please.
Apologies for coming in late when I agreed with Raj to do this. I looked at the wrong boarding pass. I went to Dumaguete yesterday and 7 in the morning, so I thought I'll be here by 8 o'clock. But actually the the return flight was actually at 8 o'clock, 8:30, so I only just arrived literally. You know, I'm both a human rights and environmental lawyer as well as a professor. I keep my sanity by teaching and doing environmental work that's very specific. But this is very important, and I actually I wish I was here when Attorney Panelo, Secretary Panelo was here. I was hoping Harry was here, but I actually have a very different take with Harry. I would welcome Harry back to the UP Law faculty, to the human rights world. It would be difficult, I think, for him coming back, but people have to do jobs, and you just have to do your job. In this case, though, in the ICC withdrawal, I was obviously very disappointed looking at the statement of the president. Immediately, I actually said this could not have come from Harry Roque. Harry is more of an expert on the ICC than me. I mean, I am a human rights lawyer. I'm also a professor of public international law in various universities. But as you know, my work has been mostly on the environmental law side in terms of technical work. But I followed the ICC through the years as a human rights lawyer, and particularly because as a public international professor, I actually used the ICC as a starting point for discussion of international law. It's actually one of the best treaties to start a discussion of the nature of international law. Because why would a state like the Philippines, why would the president of a state agree to join the Rome Treaty that essentially says that if certain things happen, I'm willing to be accountable, or I'm willing to make my officials, and not just state officials, but even non-state officials, non-state organizations can be liable under the ICC. So why would a government even do that? I mean, it's the nature of as a decision. And the reason is obvious. I mean, it's actually very basic international law, what we call the theory of auto limitation. I mean, Jelinek's theory of auto limitation, which is asking the bar exams for the law students here. We have international law because we need it. And some states, all states need international law, all states need international agreements, and some states need that more than others. The more powerful states, they don't need international law as much as less powerful states. But states like the Philippines, we badly need international law, including to deal with domestic situations when we cannot deal with them properly. And that's the whole concept of the International Criminal Court. The reason why we agreed to it was actually because of our experience with Marcos and even some experiences under the Arroyo government. And that's why under the Aquino government, the decision was made to sign and to ratify the Rome Treaty that we become part of. I mean, and so the reasoning is quite clear about that. The reasoning also, if you want to withdraw from it, is also quite clear. But the grounds with which the president stated, which is part now of official policy because it is an official document from the president, I suppose, and I suppose this was written by the office of Attorney Panelo, Presidential Counsel Panelo, is quite funny if you ask me. I mean, from any standard of public international law, or even basic Philippine law. I mean, if you recall, if you look at that 15-page document, there's the argument that the treaty has not been published, therefore it should not have any effect on anyone in the Philippines. If you follow that logic, all the treaties that we have entered into would not have such an effect then. Remember, Tañada versus Tavera extended this to all laws, not just to penal laws, but all laws would have no effect unless they are published. But that's quite clear with us that the moment we ratify an agreement and we deposit that ratification agreement, that treaty becomes part of the law of the land. The idea that fraud was committed on us because we were fooled to join the ICC is ludicrous, right? I mean, it's just a ridiculous idea to think about. First, because we very well knew what it was all about. I mean, what the ICC was all about. This was debated for almost 10 years in the Philippines before we finally joined. And in fact, Secretary Roque was one of the most powerful proponents of that decision. And so we did join, knowing everything that was here, that complementary is not exclusive, it's not appellate. Even when there are processes going on in your country, the ICC prosecutor, and authorized then by the pretrial chamber, can decide that there's no serious attempt to hold anyone accountable for the acts that are being committed. The idea that there was a fraud is also also falls on the simple fact that there is in fact no finding at all by the prosecutor of anything in the case of President Duterte or his people. That's very clear in the statement of the prosecutor. That in fact, the two things that she will look at will be, are the acts being alleged crimes against humanity? And that I will say is very obvious, very clear if you look at the definition of crimes against humanity and you look at the elements of that crime. I think the war against drugs and the extrajudicial killings would be crimes against humanity. But there is a real question of whether the processes that we have going on, particularly the Supreme Court cases, the Tokang case in the Supreme Court, for example, is something that can, in fact, signal to the ICC prosecutor that we can take care of this ourselves. I mean, so that for me is something to really examine very closely, and for the ICC prosecutor will be doing that. So it's really premature to say that. I mean, I think if you read the statement, the president, he actually believes that the prosecutor has decided to investigate him and to move to the next stage. And there is absolutely, totally no basis for saying that from the statements of the ICC prosecutor. So it's something to look at. A third point in my opening, and then I'll field questions, is very very basic. I mean, in decisions on international law and foreign policy, it's, I think, very important not to decide this on the basis of a moment in time, on the basis of the vulnerability of a president or the vulnerability of his people. I think it's very important to look at it on the basis of what it means for the country, what it means for the people of the country for the future. And so I go back to what I said at the beginning. The reason why we decided to restrict our sovereignty in the case of ICC and say that under certain circumstances we will allow ourselves to be investigated and to be held accountable under the Rome Treaty. The reason is that there was a decision, including concurred in by the Senate, that this is good for the country and good for our people over the long term. If you read the preamble of the ICC, this is in the end really about impunity, a recognition that there is a lot of atrocities in the world. This happens. Countries domestically should confront them and should stop them and should hold people accountable. But sometimes the international community needs to act together. Sometimes a country actually needs to ask for help. And us joining the ICC simply saying that in our history, and I will not, this is just a moment, the Duterte term, the Duterte period, but even, you know, I mean, some would even argue that during the Aquino years, there's also certain events that could actually be within the ICC as well, certainly in the past. And so there's this belief, there's this conclusion that in fact we need the ICC more than the ICC needs us. I mean, and so with that I end my opening remarks and will field questions. Thank you.
Thank you very much, Professor Viña. We have 10 more minutes for questions. I understand the gentleman in the back has some questions. Yes, please. Kindly state your name and then address your question to either of the speakers.
I am, sorry. Hello, hello. I think it's, hello, hello, yeah. I am Attorney Chris Roman. I am an Assistant Secretary at the Office of the Chief Presidential Legal Counsel. But mine is a personal question as a lawyer and a citizen of the country. My question is addressed to CHR Commissioner Roberto Cadiz. Sir, as Commissioner of the CHR, sir, do you think that the government, or in particular your office, is unable or unwilling to investigate or prosecute the crimes alleged in the complaint before the ICC, sir? Oh, is the government, do you think that the government, or in particular your officer, is unable or unwilling to investigate or prosecute the crimes alleged in the complaint brought before the ICC?
Many cases. It's working, sorry. In general, yes. In fact, I would go further. The government is actually commanding the commission of extrajudicial killings against the people, to the level that it has almost reached that level of policy.
Sir,
it is not only unable to investigate or unwilling, it has adopted this as a policy, as a strategy to addressing the issue on drugs, the problem of drugs.
Sir, are we saying that the CHR is ineffective in pursuing its
No,
mandate?
when
sir?
you were you referring to government or the CHR?
Sir, I think CHR is part of the government, sir. So
actually, in
well,
a sense, yes. We are part of the bureaucracy.
Yes, you
we are
yes.
government employees. We receive salaries from taxes of the people.
Yes, sir. Yes, sir.
But in terms of mandate, we are not part of government. We are called the National Human Rights Institution.
Yes, sir.
We, in that sense, we are not part of the government. Oh.
Yes, sir.
People would think that I want an ICC case. I actually don't want one. As a human rights lawyer, as an international lawyer, I go 4, 5, 6 times a year. It is embarrassing, it's shameful, because it's actually a judgment. An ICC case is a judgment that your legal system does not work, and your justice system is completely unable to respond. That's what I want to do. So I'm actually against this. And from the very beginning, I've said it's so easy to avoid this case. It's so easy. You know, first the president has to stop giving speeches that instigate the killings. That's first of all. Because it doesn't matter whether it's a joke, whether it's cultural or not. These are going to be international lawyers, the best international lawyers in this field in the world, that look at this, and they will not be judging it, this is a Philippine, they will be judging it from international norms. You know, and so first the president should stop doing that. 2, the CHR's budget should be triple, quadruple. Because my problem is, with the CHR, the DOJ, etc., the real question of the ICC prosecutor here is, where are the cases? Have there been any investigation? You know, any killing by police has to be investigated. And by the way, we actually have those, but the police is refusing to give it to the Supreme Court. Because I think it will show very clearly what the circumstances of the killings are. So all that you have to do, the way I see it, for example, the police should tell the Supreme Court, here are all the investigations. We are investigating this. We are investigating this. That's very important, I think, in the Tokhan case. So in other words, there's ways to looking at whether or not, you know, we have been serious about this. I think unfortunately the CHR has been so marginalized in all of this. Otherwise, it would have been the best defense. The best defense against the ICC is a CHR that's well funded, that's not demonized,
that's very important because the CHR has been demonized. The chair has been demonized by the president. I mean, I think they're very brave. I know I've always given my admiration to all the commissioners and to the chair about it, but they have been demonized. And then the president. Now will prosper because I think I am also an international law professional. When I do investigations also myself for certain certain things, and I follow very strictly the norms of transparency, integrity, factual, no speculation. You actually look. So here the only question is how many cases have been filed? How many extrajudicial killings have been solved? Those are the simple things that have to be looked at. So if you actually did all of that, there will be no case. Complementary will certainly work.
Let me give an example, just to.
Yes.
We have actually reached out to the government. I don't know if many among us here know it. All 5 commissioners of us actually reached out. We have sought audience with the president. We have in fact visited the PNP chief. We have entered into agreements with the PNP chief to help them investigate. And in fact, the PNP chief agreed to share their case files with us after that meeting. But then when we came back to collect the files, he had to admit to us that upon clearance with the president instructed him not to share any of the case files pertaining to extrajudicial killings with the CHR.
But sir, you will agree with me that the courts are very much working, that the CHR can proceed.
The courts all over the Philippines are working.
Yes, sir.
But not in regard to extrajudicial killings. And that's why the International Criminal Court is, its authority has been invoked.
Thank you, sir. Thank you, sir.
I think we have time for one more question, and then we're going to thank our speakers and request the UP College of Law representative to give the closing remarks. One more question? Aside from Attorney M, are there other questions? Okay, Attorney M. Hill, please.
Sorry, I have to speak, and thank you for the indulgence, Attorney Palacios. I agree definitely with Professor Viña that as an individual practicing international law, not in the Philippines, and also as a citizen of the Philippines, I was actually not very happy, or I did not look forward to an ICC case being filed about the Philippines. Aside from the fact that it is embarrassing, but also because I believe that if we prosecute and effectively handle these cases domestically through our court system, that is actually a huge improvement to combat impunity in our country. Attorney Panelo mentioned earlier that, well, we don't need the ICC. We were able to overthrow Marcos. We were able to overthrow Estrada without the ICC. But look, where are they now? The family of Marcos have started walking the halls of powers again. And Estrada is the mayor of the city of Manila. So impunity is still there. They are back in power. They have not been adequately punished. So we do need structures like this. And second, if you are part of the government, I would like to plead that please read your laws. Because if you say that the CHR has prosecutorial powers, then you haven't read the Paris Principles. You do not know what the NHRI actually is. So if you want to argue against international law, if you want to say that the CHR, and I'm not defending the CHR because I know that you guys have problems as well, but if you want to argue that the CHR should act, then argue well. That is your responsibility as a lawyer.
Thank you very much. Maybe we'll ask 1 minute closing statements. First from Professor Viña and then Commissioner Cadiz.
The reference to the past is important for impunity.
what gives me hope now, whether it's through the ICC or through processes that will come later on, is that so many of these atrocities that we see around us now is being documented, no? Visually documented, legally documented. If ever this goes to the ICC or to some domestic process later on, the case build-ups would be very, very interesting to look at. I mean, I've talked to victims myself. I've been in forums with victim families. It's quite incredible. The case build-up being done already right now. In the case of the ICC, you know that at the point that it's doing the preliminary investigation, and then when it goes to the pre-trial to ask for authorization of investigation, victims can already come. And I suppose I'm not involved in any way with this because I prefer to look at this from an academic point of view. But I suppose those victims are also now preparing their own interventions. They actually get to go to The Hague, get to present their side. Because that's one of the missing, in the literature of the ICC, you will see that. One of the missing parts of the ICC was the rights of victims, how victims could be incorporated more into the process. I mean, I think as the ICC matures, they realize that was so important. And what gives me hope in the Philippines is we've actually had done a very good exercise with the Marcos, with the Marcos era, with the compensation claims that were done. Imagine 20, 30 years ago, this events happened 20, and now we are doing these things on real time. I mean, the press is here. I think there are people in the press, no matter how challenging, difficult, it's no longer sexy to necessarily cover it. They still cover it, cover this I would say crimes against humanity that's happening around us. I mean, so that actually gives me hope, and that, I mean, the thing here is not about just putting people in prison. It's about highlighting atrocities that are committed by state or non-state that requires accountability. And I think even the act of preliminary investigation is already a victory against impunity just by itself, even if it doesn't go further than that.
I wish I were a professor too, like Tony. Anyway, just the observation. Professor Tony is seeing the light at the end of the tunnel. He has farther vision than I. Just the observation that the impunity in regard to the killings, I've noticed that it's now spilling into democratic space. There's now shrinking democratic space, and it's before it was just impunity with regard to criminality, and now our freedoms are slowly being suppressed before we reach the end of the tunnel. The Chief Justice will already be tried in the Senate soon because the articles of impeachment have already been determined and many things. Even one time when I spoke about this, I was sent a show cause order unimaginably by Congress to explain why they should not cite me in contempt for speaking about the impeachment process in the lower house.
Thank you, Commissioner Cadiz. Before we invite College of Law Secretary, Professor Dizon Reyes, I just want to thank, please join me in thanking Commissioner Cadiz and Professor Viña for sharing their thoughts, and also Secretary Panelo, who was here earlier. I also want to thank the UP College of Law on behalf of the IBP, as well as our partner institutions, the Philippine Bar Association, the Lyceum College of Law, the University of San Agustin College of Law, the University of Negros Occidental Recoletos School of Law, and the Center for International Law here in Manila. So may we now invite College Secretary, Professor Maria Gisela Dizon Reyes for closing remarks.
friends, colleagues, and students of law. Magandang tanghali po sa ating lahat. I would like to thank, of course, our partners in putting up this forum, a legal forum on the withdrawal of the Philippines as party to the Rome Statute. I'd like to thank our partners, the integrated part of the Philippines, and the other partners. I cannot read all of them from how small the logos have become. But I'd like to say, on behalf of our Dean, the Dean of the UP College of Law, Dean Fides Cordero Tan, I'd like to thank all of you for attending this forum. We live in, I think, very interesting times. And I hope this is not the last of our forums. I hope that in the future we would have more forums for academic and intellectual discourse. So with that, I think, again, maraming salamat to our speakers, to Professor Raj, of course, who has been really instrumental in putting up the program. Maraming salamat sa inyo lahat.
Rafi, pakuha naman. So, mabilisan lang tong forum. Wala nga tayong photographer. I've requested my student, si Mr. Rafi Recalde. Mataas na maging grade mo, sigurado.